Protecting people's rights when it comes to personal life choices or bodily autonomy up until now was something that had been extended, not reversed or restricted. However, Justice Thomas has made it clear in his concurring opinion that the reasoning used to reverse the Roe v. Wade decision should be applied to other past decisions that he also perceived as wrong and as such would need to be revisited. As the Due Process Clause of the 14th Amendment is the basis on which the Roe v. Wade decision was founded, what are the other rights that stem from the same basis and that are potentially the target of future reversals? The right to contraception dating back from 1965, same-sex consensual relations dating back from 2003, and same-sex marriage dating back from 2015 are all based on the same reasoning as the Roe v. Wade ruling, although Justice Alito insists on the fact that the right to abortion is different. Justice Thomas underlines the fact that the Supreme Court's decision relies on a reasoning that can and should be applied to those other rights, and he explicitly mentions them as worth revisiting. Indeed, for Justice Alito, the right to abortion was not deeply rooted in U.S. history and tradition, but neither are the rights to contraception, same-sex consensual relations, and same-sex marriage. The current Supreme Court does not recognize that it is bound by precedent, and the majority of its judges is mainly interested in the accurate way of understanding what was historically meant by those who wrote the Constitution. What actually stems from its principles is not their guideline, so it is fair to say that other rights are potentially next on the line, and Clarence Thomas is only being upfront about it, signaling an openness in matters the court has not been asked to rule on.